Hello everybody, this is Mr. Lipchick again, and today we're going to talk about the right to free speech. Very important First Amendment right, which many lawyers believe is at the center of all of our other rights. Okay, the First Amendment protects our freedom of speech. It protects unpopular ideas as well as those that are popular. Free speech is a basic human right. There are two types of speech. Pure speech, which is verbal expression of thought and opinion before an audience that has chosen to listen. And there is symbolic speech, using actions and symbols to express ideas. And on the right, you will see a young man burning the flag. This has always been a controversial form of symbolic speech, but every law that has been attempted to outlaw the burning of a flag has been ruled unconstitutional for that reason. It is symbolic speech, it is offensive speech to many people, but it is speech nevertheless. Pure speech is the most common type of speech. It can involve public speeches or words spoken to others in private. And because this type of speech relies on the power of words to communicate ideas, it is the most carefully protected by the Supreme Court. Symbolic speech, on the other hand, symbolic speech is sometimes called expressive conduct. Symbolic speech is sometimes subject to restrictions that pure speech is not. On March 31st, 1966, David Paul O'Brien and 3 other men publicly burned their draft cards in protest of the Vietnam War. And O'Brien was arrested, convicted, and sentenced to 6 years confinement. His conviction made its way to the Supreme Court of the United States in United States v. O'Brien in 1968. The Supreme Court ruled against O'Brien. The court ruled that the government can regulate expressive conduct if the following 3 conditions are met. Number 1, it falls within the constitutional power of the government to do so. 2, it is narrowly drawn to further a substantial government interest that is not related to suppressing free speech. And it leaves open ample alternative channels of communication. In this case, they basically said O'Brien could have made a sign, he could have protested in another way. Okay, so the speech can be regulated to a certain degree. None of our rights are absolute. The right to free speech must be balanced against the need to protect society. Congress and state governments have outlawed what is known as seditious speech. Any speech urging resistance to lawful authority or advocating the overthrow of the government. That is the definition of seditious speech. There are 3 constitutional tests to justify limiting free speech. 1, the clear and present danger rule. 2, the Bad Tendency Doctrine. And 3, the preferred position doctrine. All 3 of these need to be considered when deciding if speech is seditious. The clear and present danger doctrine. When speech presents an immediate danger, it is not protected by the First Amendment. If you see to the right, picture of draft office of World War I. During the war, socialists of the Allied and Central Powers urged resistance to the draft because they did not believe that working men should fight each other for the benefit of the wealthy. The clear and present danger doctrine was developed in Schneck versus the United States in 1919, and that shouldn't be Schenck. I made a mistake there. It should be Schneck. Charles Schneck, a socialist, was arrested for violating the Espionage Act of 1917 when he distributed pamphlets urging men to resist the draft. Schneck argued that his speech was protected by the First Amendment. And the court rejected this argument because encouraging men to resist the draft endangered the nation, and therefore the First Amendment did not apply. Then there's the Bad Tendency Doctrine. Some of the justices of the Supreme Court did not feel that the clear and present danger doctrine was adequate to protect the interests of the federal government. In Gitlow versus New York in 1925, they ruled that speech could be regulated even if it only had a tendency to lead to illegal action, establishing the Bad Tendency Doctrine. And the court balanced the need for free speech with the need to protect society. And finally, there is the Preferred Position Doctrine. This doctrine, developed by the court in the 1940s, holds that the First Amendment freedoms hold a preferred position against other competing interests. The First Amendment freedoms are the basis of all other liberties. And any law limiting the First Amendment freedoms should be presumed to be unconstitutional unless the government can show it is absolutely necessary. Okay, so this basically kind of balanced out the other parts, the other two doctrines we talked about. It said the burden is on the government to show that this speech is not protected. Sedition laws are laws prohibiting seditious speech, and a number of them were passed. And in the 1940s and 50s, sedition laws were passed in peacetime during the Cold War. We were very frightened of the Soviet threat, which you see on the right in red. And the laws were directed at communists. The court upheld the conviction of 11 communists under the Smith Act, which made it a crime to advocate revolution. The court eventually, however, created a more narrow definition of seditious speech. Convictions of many communists were overturned. And in Brandenburg versus Ohio in 1968, Clarence Brandenburg was arrested for holding a KKK rally and not disbanding when ordered to do so by police. The court ruled that he had the right to advocate the use of force as long as he was not inciting or producing imminent lawless action. And by imminent, it means, immediate. Okay, so, getting people together to commit an immediate violent offense. Okay, he was just stating that this was something, it was a principle that he favored. Another form of non-protected speech is defamatory speech. This is false speech that damages a person's character, reputation, or good name. Courts have ruled that your good reputation is considered property and that you can recover monetary damages when it is taken from you. There are two types of defamatory speech. There's slander, which is spoken defamation, and there is libel, which is written defamation. And Carol Burnett, the comedian you see on the right, comedian, successfully sued the National Enquirer for libel. And the Enquirer tried to say, well, nobody really takes our publication seriously, it's full of gossip, and the court ruled against them, and she got a very huge settlement. These protections, however, do not extend to public officials and public figures. The exception is if false information is given knowingly or with reckless disregard for the truth. Public officials are expected to endure a certain amount of defamation in order to ensure that people feel free to criticize them and their policies. On the right, you see a picture of General Westmoreland, who was in charge of the Vietnam War, and he tried to sue CBS News for giving critical appraisals of his performance, and he was unsuccessful. Fighting words is another form of non-protected speech, and it constitutes speech that is not protected under the First Amendment. In Chaplinsky versus New Hampshire in 1942, the Supreme Court upheld a state law that prohibited people from speaking any offensive, derisive, or annoying word in a street or public place. And the standard is that if the very utterance of these words inflict injury and intend to incite an immediate breach of peace, then they are not protected. Unprotected speech includes lewd, obscene, profane, libelous, and insulting or fighting words. The Supreme Court has limited student speech. In Tinker versus Des Moines School District in 1969, the court upheld the right of students to protest the Vietnam War by wearing black armbands, as it did not disrupt the functioning of the school. There's a picture of the Tinkers on the right. They just summarized it right in the last sentence. It did not disrupt the functioning of the school. If it does disrupt the functioning of the school, the students can be suspended. In Bethel School District versus Frazier in 1986, the court ruled that the First Amendment does not prevent school officials from suspending students for using lewd or indecent speech at school events. And in Hazelwood School District versus Kohlmeyer in 1988, the court ruled that the school could regulate student speech in school newspapers, theatrical productions, and other activities that were part of the school curriculum. So in other words, you can't have students, on a school newspaper, which is owned by the school, libeling the school, libeling its employees, and doing things like that. Okay, that concludes our presentation. Thank you for attending, and I look forward to seeing you in the live lesson. Have a great day.